Yes, please.
From the main list, item number 1.
If it is very urgent, otherwise after the vacation.
My lord, this is urgent matter.
What is the urgency?
My lord, here, my lord, the petitioner, she is a woman, the age of 50 years. And my lord, she was advised by the doctor. She was married since 2020. And after several attempts also, my lord, she was not able to conceive. So she was advised by the doctors from the Ganeshdas hospital that she should go for IVF treatment at IHR Guwahati. When, my lord, she has visited there, my lord, they have refused to give the IVF treatment on the ground that the law, that is Assisted Reproductive Technology Regulation Act 2021, my lord, that I have enclosed as Annexure 3, page number 17.
This is a writ application.
Yes, my lord. So,
What interim order you are asking?
my lord, I have challenged the provision of the act, that is section 21, 21G.
That is all right, but
Here, my lord, what I am praying, my lord, in the interim, that she should be allowed to avail the benefit of IVF treatment.
there is no prayer for interim relief.
I have filed my miscase, my lord. Similarly, by other high courts also similar prayer was allowed, my lord. In interim relief, the petitioners were allowed to go for IVF treatment. Because of the bar that is provided under section 21G, age limitations.
What is IVF treatment?
My lord, that is in vitro fertilizations. My lord, what it does is, in the laboratory, my lord, the woman's egg is fertilized with a sperm outside in the laboratory dish, my lord. Then thereafter embryo is placed inside the womb of the woman, because this helps various pregnancy issues, my lord, to overcome. So, my lord, here, because of the bar that was there, that is there under section 21G, clause 1, that is to a woman above the age of 21 years and below the age of 50 years. Now she has just crossed 50 years of age, and because of this, my lord, they are not providing the treatment. Similar cases, my lord, went to various high courts. They have various high courts, my lord, have allowed to go for IVF treatment, because this is a clear-cut discriminations on the basis of the age. Because for a woman, age is 50; for a man, age is 55. So this is a violation of the rights, my lord, that is under Article 41, 1521, my lord.
Have you served a copy on the respondents?
My lord, I have served the copy. My lord, what I am praying is, my lord, just interim prayer, because time is a very crucial factor here, my lord.
How old is your client?
She is 50 years, my lord, just crossed 50 years.
And how many months?
And 9 months probably, my lord.
Yes, so
See,
50 years, 9 months, so 1 month will not make a difference. Let them file their affidavit.
My lord, here, my lord, the crucial point is, my lord, the age, as I have already stated, my lord. Only pray, my lord, what I am praying is,
No, we have to examine what are the risks involved of
my lord, may
this
kindly
treatment
see,
being under.
my lord, there is a similar case, my lord.
Similar maybe, but all the facts may be different. There may be medical reports supporting it.
My lord, here it is supporting, my lord. My lord, may kindly see my writ petitions, my lord. I have enclosed the report, my lord, from the doctors.
If you are entitled to interim relief, you will get it after 1 month.
My lord, may kindly see page number 15. I have enclosed the medical fitness certificate, my lord.
This is a general fitness certificate.
Yes.
Yes, 15 is a general fitness, my lord. This is
Yes.
not reproductive fitness, my lord.
My lord, that is
Dr. Mazika, whom are you representing?
Number 1, Union of India. There are only 2 respondents, only Union of India and State of Meghalaya.
Both.
No, my lord. State will be represented by Advocate General, my lord.
my lord. Here, I have no issue, my lord, if Advocate General appears in this case, but only thing is for now, my lord, my interim prayer may kindly be granted, my lord.
No, no.
Well, interim,
You wait for 1 month. Let them file their affidavit. Let us examine the medical risk involved.
My lord.
This court cannot be so rash. And then we will order that, then something will happen to the patient, then who will take the risk?
My lord, page number 15, there is a fitness certificate which was granted by the,
This is not entirely a legal matter, it is a medical matter also.
my lord.
So the specialists have to express their opinion or the facts.
My lord, this is,
What is the benefit of this? What risk is involved? At what age? What are the consequences, etc.
my lord, as far as this case is concerned, relating to this kind of cases, my lord, it is always the health condition of that person concerned. It cannot be general, my lord. If the person's concerned is fit and fine, my lord, they can be allowed with the treatment, my lord. It cannot be general.
Yes. Which hospital she is going to?
Guwahati, my lord, IHR Guwahati, my lord.
They are willing to do it.
They are willing as long as, my lord, give some interim order, my lord. They said they will be. Even other high courts also, they have similarly ordered.
the jurisdictional issue also will come up.
That is different thing, my lord. There's
1 month will not make a difference. We will keep it on the 28th or 27th of January.
Lord,
Or
because
we will,
she has already crossed 50, my lord. That is the only
she will
concern.
cost 100 in one month.
No, my lord, that is.
Please take down. This writ petition is admitted. Next, it seeks a declaration that section 21(G) of the Assisted Reproductive Technology (Regulation) Act 2021 is ultra vires the Constitution. Paragraph. It is said that the petitioner is just over 50 years of age and should be allowed the benefit of this technology although the Act bars such procedure over the age of 50 years. Next. As an interim measure, this treatment is sought. Paragraph. We are unable to accede to this prayer at this point of time. Dr. Mozika, learned Deputy Solicitor General of India, representing the Union of India, and give her name. Learned Counsel appearing for the state are requested to take instructions in this matter. Next slide. Which hospital?
IHR Guwahati, my lord. IHR Guwahati.
Yes. IHR Guwahati, the hospital treating the petitioner shall constitute a medical board immediately and file a report in this court to a learned advocate as to whether IVF treatment can be received by the petitioner at this stage.
Well.
Paragraph. List this writ on 27th
Well.
January 2024
And if
to
I,
consider afresh grant of an interim order.
Lord, IHR full form is Indian Institute of Human Reproduction.
All right.
Institute of Human Reproduction.
IHR is Institute of Human.
Assam, huh? Guwahati, Assam. Obliged.
Item number 2.
please, Your Lords. This is an appeal directed against the judgment on order dated 2/12/2024. Limited issue, my lords. Writ petition came to.
Mr. Paul, are you praying for any interim order?
I'm sorry, my lords.
Is it very urgent? Otherwise, we'll take it
Well,
up.
there is an eminent urgency, my lords, which is why we made a mention of this matter, because there's a direction, my lords, not only of imposition of costs, there's a direction to initiate disciplinary proceedings against the members of the corporation, my lords. That is why we are here before your lordships.
And it's an appeal.
It's an appeal, my lords. Limited issue, my lords. I'll not take too much time. Two issues, my lords. What happened is a writ came to be filed before this honorable court.
We will list it again on 28th or 29th. Status quo regarding disciplinary proceedings and payment of costs and payment of costs to be stayed for the time.
My lords, I'll be grateful.
We admit this appeal. List it once again on 29th January 2025. It's for the respondents.
My lords, Union of India.
The private party is there. You should.
Till 12th February or until further order, whichever is earlier. The direction contained in the impugned order to initiate disciplinary proceedings and for payment of costs shall not be given effect to.
Your Lordship, here I am appearing on behalf of Union of India, Your Lordship. There is private party also, Your Lordship. I am not appearing for private party.
Private parties involved, how?
Private party was the original writ petitioner whose writ was dismissed, my lords. He is not affected by this order. It is only they say that there is a wrong statement made by the corporation on an affidavit on which this cost has been imposed. We tried serving the private petitioner as well.
Disciplinary proceedings must be at his instance.
No, my lords, it's at the court's instance. The court says, my lords, that you have made, you suppress them.
Private party is on record as a party.
We've made him a party, my lords.
All right.
We'll serve him, my lords.
Let notice
My lords.
of this appeal and the gist of today's order be served on the private respondent by Dasti service.
My lords, I'm obliged.
And an affidavit of service filed before the returnable date.
My lords.
Item number 3.
Please, Your Lordship.
Yes.
Lordship, I will not take much time. This is an appeal, my lord, against judgment passed by learned single judge. Matter, my lord, revolves around the reconstitution of the managing committee of a school, my lord. Now,
No, but what is the urgency? Otherwise, we will take it up after the vacation.
Lordship, the urgency is that on the basis of the of the learned single judge's order, respondents appear to have already started taking steps, my lord. So, if my lord observes that no steps are to be taken,
What steps have been taken?
the respondent number 5, the private respondent, has issued notice for calling a meeting, holding of elections of the managing committee, my lord. So, if no steps
That
are
is a
taken,
no. That any steps taken will abide by the result of the appeal.
would be subject to the outcome.
Your Lordship, in fact, the election has already been held
Yes.
and the management committee
The
is...
usual order is.
No, I mean, Your Lordship, the managing committee has already been constituted and approved by the government. So any such order by which
No, we are just saying that any
this
steps.
matter appeal has become infructuous, Your Lordship.
That can be argued as long as
The
honorable
appeal has
court
become
observes.
infructuous because the government has already given approval to the new managing committee that was constituted as per the direction of this single bench, Your Lordship.
No, but what was the challenge in the writ?
The challenge was that, Your Lordship, in the writ petition, that the
Lordship, if I can take a minute to explain.
the managing committee
take a minute.
constituted by this appellant, Your Lordship, was not in order, which is why, and they had not filed their affidavit in spite of ample opportunity having given to them. So the single judge has directed that in the interest of the students and the school, the managing committee should be constituted. So in the meantime, Your Lordship,
If we succeed in the appeal, this committee will be declared null and void.
Absolutely, my lord. Absolutely.
but
So we will just say that any steps taken further to the impugned order will abide by the result of the appeal. That's all. We are not staying anything.
Obliged, my lord.
May please, Lordship. In this case, I am for the private respondent. Of course, they have not served a copy to me. Notice has not been issued to me, but I will bring to the notice of this honorable court that
Also,
what my
also, my lord.
You are private, your respondent number?
for the managing
5.
committee, respondent number 5.
All right.
So, Lordship, may please to kindly, what my learned single counsel has submitted that this order which was passed by the learned single judge has been complied with and the managing committee has been constituted. So, this petition has, the writ appeal has become infructuous, Your Lordship. And the prayer made by them in the writ appeal, it has become infructuous, Your Lordship.
All right. Although the respondent number 5 is represented in court by learned counsel, it is submitted by her that no copy of the cost papers has been served upon her client, we direct immediate service of the cost papers on the respondent number 5 by the advocate on record for the appellant by Dasti service,
Very well.
and an affidavit of service to be filed in court before the returnable date. Paragraph. We admit this appeal. Paragraph. It is submitted by learned counsel for the respondent numbers 1 to 4 that the managing committee of Madrasa Himayatul Islam LP School Shillong has been reconstituted for a period of 3 years with effect from
your date of constitution.
20 August 2024. Further to the impugned judgment and order passed by this court. Paragraph. We only
Government has
observe that such reconstitution will abide by the result of this appeal. Have been reconstituted on 13 December 2024.
And approved by the government, Your Lordship.
It's been reconstituted by the government itself.
Approved.
Has been
No, this approval
reconstituted
by the government.
by the government of Meghalaya on 13 December 2024. Paragraph B. Expedite the hearing of the appeal, dispensing with other formalities. Paper book by 20th February. List on 3rd March.
Obliged.
Later.
Item number 4.
May it please, Your Honor.
Item number 4.
This is a hearing matter.
This is order actually. Supposed to be order. Should be in order.
After vacation, this matter.
Number 4.
Mr. Advocate General?
Yes, my lord.
After vacation.
Yes, my lord. This Meghalaya College teachers matters, my lord.
After vacation.
After vacation.
The window is actually 4.
This college teachers matter. Yes, ma'am.
By consent of learned counsel for the parties, lists this writ petition for hearing on 30th January 2025.
Item number 5.
Where is the court order directing this matter to be listed? Where is the court order? Last day you're listing whole hordes of matters. Where is the court order? After vacation.
Your Lordship, this is just an application for continuation of delay, my lord.
No, after vacation. When have you filed the application?
Last week, my lord. On 10th December 2024.
How is it appearing for orders? Delay of 350 days.
No, actually, the actual delay is only 11 days because the earlier, this same appellant, he has filed a writ petition challenging the same impugn order. And the writ appeal, the division bench has allowed to withdraw the appellant hearing and allow him to file the review petition. And in compliance with the order of the division bench, he has...
Or for the state of Meghalaya.
Yes, there is
I'm
a
appearing
state
for
of
the state, Your
Meghalaya.
Lordship.
The report of the registry says 350 days delay.
Yes, 350 days is counting from the date of when petitioner, the appellant, was allowed to withdraw that writ appeal earlier and to file a fresh the review petition. Then, on the basis of the order of the division bench, he withdrew the appeal and file a review. The review was dismissed. Now, I am challenging against the order of the impugn order as well as the order of the.
They are challenging.
I am challenging. The challenge of the order is because that there is a division bench, that a single bench has, in that single bench has passed an order that there will be an inquiry, the report will be submitted to the court. And after submitting the report, that report will be provided to the appellant hearing and opportunity will be given to the appellant to address to the court with regards to the report filed by the Commissioner
It's an
Secretary.
application in the appeal.
Yes, this
Application in the appeal.
yes, it is the application in the appeal. This is this case, this for condition of delay.
Your application.
Yes, this is my application. I have stated in my application, my note, this I have even enclosed the order of the division bench and also the single bench, the review where review petition, the order was passed in the review. This one. The delay is actually is caused due to the writ appeal earlier and also due to the pending of the review petition before the learned single bench. From the date of the review petition till filing, we have only 11 days, but we have counted from the date when the the appeal was filed. Actually, this delay is not caused by the petitioner, but it was because due to the fact that there was a delay because that some days was pending in the division bench as well as in the single bench.
Division bench, you withdrew the appeal.
We withdrew the appeal and directed me to file the revision petition. I filed a review petition and it was dismissed.
You have not sought the benefit of Section 14 of the Limitation Act? Pending in a court without jurisdiction? Wrong court? Section 14 Limitation Act.
That I have
Exclusion of time?
actually,
Then
there's
if at all, we do not know whether that would be applicable or not.
but from the disposal of the review till filing, we have there is a delay. Of course, only 11 days delay was there. Otherwise, my lord, I have the merit. If we go by the merit, I have the merit of the cases there. Lordship, it's on the face of record.
Well, can we condone it?
May this is your lordship. Lordship, there were 7 writ petition, your lordship, before the learned single.
No, are you opposing this prayer?
Certainly, your lordship.
Then you file your affidavit.
Lordship, a notice also will have to go to respondent number 4, your lordship.
So you file your affidavit.
Lordship.
You also consider Section 14 of the Limitation Act.
Lordship.
All right.
Lordship, notice will have to go to respondent now, opposite party number 3 and 4, your lordship. There are 4 opposite parties, your lordship, in the.
You are 1 and 2.
Lordship, I'm for the state 1 and 2, your lordship, yes.
All right. The respondent numbers 1 and 2 are represented by learned counsel. Let service of this application be made by the advocate on record for the applicant of the respondent numbers 3 and 4 by Dusty Service and an affidavit of service filed before the returnable date. Let a copy of this application along with this order be served. Paragraph, the respondents are at liberty to file each respondent is at liberty to file an affidavit in opposition to this application by February.
Lordship, only thing is that there were 7 writ petition. Only a single appeal has been filed against the common judgment, your lordship. In this appeal, your lordship.
By all.
Lordship, yes.
Lordship, I mainly agree by the writ petition 383. Because the others, I'm not agree.
We will see that. Affidavit in reply by 21st, list this application on 24th.
In one of the writ petition, your lordship, he filed, he annexed a forged document, your
The
lordship.
point of maintainability
Lordship.
as raised by learned counsel for the respondent numbers 1, 2 and 3.
1 and 2, your lordship.
1 and 2 is kept open.
I'm highly obliged.
Item number 6.
Lordship.
We are yet to file the affidavit, my lord.
This is a hearing matter.
Not in hearing, my lord. This is in orders, my lord. We are yet to file our affidavit, my lord. Let this matter come up after vacation,
Affidavit in opposition.
my lord.
All right. Time to file affidavit in opposition is extended till 30th January. Or do you want more time?
My lord, 30 January is okay, my lord. Enough time.
4th February.
My lord.
Affidavit in reply may be filed by 14th February. List this writ petition on 17th February.
All right.
Item number 7.
I have a report, that is 16 December 2024, Your Lordship.
You are filing a report?
Yes, Your Lordship. Second page.
We declare admission.
You have the copy of this report?
No, just now has given.
It will solve your problem.
My lord, this very report clearly shows that you have failed to furnish or to supply water to us. So there is no, as per the act, as per the circulation of the government of India, from time to time, there is no bar that the water for boring of the borewell for the purpose of water. There is no bar.
Saying that if you install an individual borewell, that will interfere with the supply of the public borewell.
Yes, Your Lordship.
That is the point. There is no bar, it is all right. But if it interferes with the water supply, then they are not allowing it.
But
Because the general public will be affected.
But the fact remains, Your Lordship, that there is no proof to show that it is interfering in any way. There is nothing. From the government, there is nothing. It's only that they rely on the...
Okay, they are saying that they are augmenting the supply very substantially, 2,000 liters, 3 to 4 times per week.
That is what they
We are
say.
keeping it in February. Let us see what is the development.
But the thing is that, my lord, every day I have to buy water.
So if there is no water now, it cannot fall from the sky.
No, the problem is that the law is very much clear that I should be allowed. Reflection government.
We have considered the report. This one, huh? Of the Secretary, WBSC, Nongra, Dorbar, dated 14th December 2024. Which promises substantial augmentation of water supply by January 2025 to Nongra, a rural village. The report be taken on record. Dated 14 December 2020. List this appeal once again. On 13th February to assess the situation.
Mr. Lordship, and Your Lordship, may kindly please be pleased to issue notice upon the respondent number 5 also.
Who is respondent number 5?
That's a private respondent. The notice has not been issued yet to the private respondent number 5, Your Lordship. So Your Lordship may kindly issue notice upon private respondent number 5, Your Lordship.
All right. Advocate on record for the appellant shall issue a notice to the respondent number 5 by thus the service and affirm and file an affidavit of service before the returnable date.
I'll oblige, Your Lordship.
Wish you a very happy vacation.
Same to you, Your Lordship.